You already have an estate plan, whether you did it correctly or you have done nothing at all. And if you have done zero estate planning, nothing, nada, then most likely the state where you live in has a law in place that says exactly what will happen to your estate. Do you want your ex-husband to control your assets after death? Or do you want someone you implicitly trust who will ensure that your wishes are carried out and your family is protected? Proper estate plan will help you with the latter. What is estate planning? Simply making a plan for transferring your assets to your heirs and protecting you during incapacity. Your heirs or beneficiaries can be whomever you want. Estate planning is usually done with either a trust or a last will and testament. Why should you care? Because your ex-spouse, like I just said, could end up controlling everything. Could it end up controlling your estate? That sibling that you fought with your entire life could get part of your estate or your entire estate. That child that has a drinking or alcohol problem could have a field day with all of your money. Because estate planning is not just about what happens after death. The absolute most important aspect of estate planning is what happens if you were to become incapacitated this very moment. Let's go over the 7 basic steps for a solid estate plan. The first, make an inventory. You might not initially believe you have anything, but many of my clients are very surprised at how much they actually have. I'll put a link to our free estate planning questionnaire to get you started in the right direction, but some of the stuff you already know about and you already have. And that includes real estate, mineral interests, cars, you drive one every day, maybe you have motorcycles, maybe you have a fishing boat, a power boat, maybe you go to the lake all the time, coins, art, antiques, trading cards, those little figurines that you get every year of Comic-Con. Money-wise, you probably already have a checking account, a savings account, stocks maybe, bonds, mutual funds, life insurance policies maybe, retirement accounts, health savings accounts if you work for a big corporation. Once you have this list, put a value on everything, on each individual item, and then add it all up. You're going to be surprised about what you have. Having this overall value is important because many times parents come to us in our office and they want to divide their estate equally. So having an overall number and individual value for each item can make this equal distribution a lot easier. Number 2, figure out your family's daily and monthly needs. What do they need to live on? What do you need to protect assets for the benefit of your family, and how much are they going to need on a day-to-day basis just to live? The first thing that comes to mind is life insurance. Do you have enough life insurance so that your family can continue to live the way they're accustomed? This does not mean a windfall. This means taking into account your assets, how much additional money will be needed to provide for them. If your spouse works or has the ability to work, then that number might be lower. The key is to have enough money available to supplement their needs. Again, you don't want to do a windfall. If your spouse is still living or someone has agreed to be their guardian or godparent, then how much supplement will be needed to care for your children? This brings up a very important point. Name a guardian for your children and a backup guardian in your estate plan. This is usually done in the last will and testament, but it could be in a separate and properly executed document. Naming somebody as a guardian of your children, and even for yourself, if you were to become incapacitated, can literally save your estate thousands of dollars. I cannot tell you how many guardianship fights we have been involved in as a law firm that have cost the families thousands of dollars because they cannot agree what to do with mom or dad. Money that should be going to care for their children is instead going for court costs and legal fees. 3, document your wishes. Document your wishes with a complete estate plan with 6 essential estate planning documents to provide an umbrella of protection around you. If you've been watching any of my videos, you know that I like a revocable living trust centered estate plan. This includes at its core, a revocable living trust. If you become ill or incapacitated, your trustee, your successor trustee, can simply step in your shoes and take over. When you pass away, when you die, your successor trustee can distribute the trust assets to your designated beneficiaries, bypassing probate completely. If there is an asset that needs to be probated, the next document is a pour over last will. It does exactly what it says. A pour over will is kind of like a backup to catch that asset and put it into the trust, to pour it into the trust for distribution under the terms of your revocable trust. Unfortunately, this means that the asset will still need to go through the probate process because the asset was not transferred to your trust while you were living. And that brings up the next important document, a durable power of attorney. A durable financial power of attorney allows someone to control your finances if you are unable to do so. You're still alive. This is very important because your successor trustee only has control over the assets that are in the trust. If there is an asset that is not in the name of your trust, like a house, a bank account, then the durable power of attorney can legally transfer that house or bank account into your trust while you are still living. This is important because, like I just mentioned, usually any assets not in the name of the trust when you die will need to be probated. And remember, a durable power of attorney usually dies when you die. Next is medical power of attorney. This is similar to the durable power of attorney, but only deals with your healthcare. This is someone you trust implicitly to make medical decisions on your behalf. Most people pick different people to be in charge of their finances and their health. If you think about the people in your life, you know that some are really good with money and some are really good with healthcare, and you probably don't want one doing the other. You probably do not want the money guy deciding whether or not to pull the plug, so to speak. Speaking of that, that brings up the next very important document, and that is the advance directive. You might also hear an advance directive called a medical care directive or a living will. They all mean the same thing. They're referring to the same document. However it is referred to in your community, it spells out your wishes for medical care if you become in a persistent vegetative state. In other words, there is zero brain activity, and the doctors do not believe there is any possibility that brain activity is going to reignite. The living will can be a huge gift to your family because it tells them exactly what you want if you're in that position. It takes the burden off of their shoulders. Your healthcare power of attorney follows directions and decisions in that document. The last important document is your HIPAA authorization. I am certain that you've seen or signed one of these if you've been to see a doctor or to see medical professionals. It simply states who can have access to your health records. All 6 of these essential documents create what I like to refer to as an umbrella of protection over you and your family. Thank you so much for watching the video up to this point. I know estate planning, this whole process can be overwhelming. And so I just wanted to tell you real quick that we have a free estate planning questionnaire, and we also have a probate guide, and I'll put links to it in our description below where you can download them for free. And if you're enjoying this video, please like it. And if you'd like to see more of these, please subscribe. Now back to the video. Review your beneficiaries and pay on death designations. Unfortunately, we see this all the time where people completely forget to update their beneficiaries on life insurance and retirement accounts. While your revocable living trust centered estate plan states that what you want to happen, it might not include life insurance and retirement accounts. Remember, they have to be in the name of your trust. If you purchased life insurance years ago, or it was a blank line on a form when you first started your job at the HR office, there's a good chance that you have not updated it since then. The most important thing to remember here is that a beneficiary designation trumps a last will and testament or a revocable trust. What I mean by this is that if the trust says my life insurance is to be split between my 3 children, Adam, Jim, and Monica, but the life insurance beneficiary is Monica, then guess what? The life insurance company could care less what the trust or the last will and testament says. All the insurance company cares about, and the only thing they are going to follow, is that Monica is listed as the beneficiary. They are going to write one check to Monica, and Monica can do whatever she wants with the money because it is all 100% hers, and she is under zero requirement to share it with anybody. Same thing with bank accounts that are pay on death and retirement accounts. If the wrong beneficiary is named, then the remainder of the family is going to be in for a very, very upsetting surprise. I've seen it before. If you want that $500,000 life insurance policy to pay out to the trust for distribution under the terms of the trust, then make absolutely certain that the trust is named as the beneficiary. Check your beneficiary designations and keep them up to date. Check the estate laws where you live. Decades ago, estate planning was primarily used as a way to minimize taxes, estate and inheritance taxes. However, nowadays, only very large estates are subject to federal estate taxes. For 2023, an estate is usually exempt from federal estate taxation if it is below $12.92 million. However, some states still have estate tax taxes, and some states have also inheritance tax. That means your estate might be taxed on the estate level, and the people who inherit the money may also be taxed on their inheritance. Talk to a tax professional as part of your estate plan. This is very, very important. 6, DIY or professional estate plan. This depends on how comfortable you are with making these sometimes life and death decisions. I know this sounds dramatic, but it really depends on your situation. At a minimum, I believe you need to leave the correct documents in place to cover you during incapacity. If you have minor children, then you better have a plan in place to protect your children. Can you do it yourself? Absolutely. Online services are getting better and better, but the key problem with some of them is that they do not account for where a person lives or for very specific situations. Even where I live, the legislature inadvertently changed laws recently that had an adverse effect on healthcare power of attorneys. It took them over a year to fix the problem and required some creativity that might not have been available for an online estate plan. The biggest problem we have seen with online plans is user error. If you input the wrong answers, then the output is also going to be wrong. We have also seen problems with the execution of documents. For example, a last will and testament can have very specific procedures for a legal execution. If it is not signed correctly or it does not include an attestation clause, it might be invalid. Like I said, online services are getting better, but if you have questions, then it might be worth it to at least speak with an estate planning attorney. Even if they charge you for an hour of their time, it might still be worth it just to see what your options are. Review, review, review. If you're baking cookies, you just don't throw them in the oven and come back a couple hours later. At best, they're going to be burnt to a crisp. At worst, you've got your oven and maybe your kitchen on fire. Some people like soft cookies. Some people like them just a little crispy. To bake those chocolate chip cookies exactly how you want, you're going to keep checking on them every so often. The same thing with your estate plan. Life changes. In order for your estate plan to work exactly like you want it to work, then you need to continually check on it and make adjustments as needed. Changes that require a review of your estate plan might include marriage. Maybe you get remarried, maybe a son or daughter gets remarried, divorce, maybe they get divorced, a death, a birth of a new child, a birth of a new grandchild. Revisit your estate plan when life circumstances change. I tell all my clients I want to meet with them at least once a year. Just like you should be going to the doctor or meeting with your financial advisor, CPA, or insurance guy once a year, you should also be meeting with your estate planning attorney just to make sure your estate plan does what you want. These 7 things do not happen overnight. Start slowly and build an estate plan that does exactly what you want. I know I've thrown a lot at you today, so that's why we've prepared our free guide on estate planning. I'll put a link to it in the description below and in the comment section below that so that you can download it and get started in the right direction. And to help you out even more, watch this video up here and this video up here. If you enjoyed this video, then guys, please smash that subscribe button and click on the like button. And also click on that little bell so you'll get notified every time we post a new video. Have a great day and an awesome week. And as always, thanks for watching.